May I ask you another question about the clarity with which Congress spoke? This law was proposed and enacted some weeks after this court granted cert in this very case. It is an extraordinary act, I think, to withdraw jurisdiction from this court in a pending case. Congress didn't say explicitly it was doing that. It hasn't done it, as far as I know, since McCardle, but there Congress said we are withdrawing jurisdiction in this very case. It didn't say that here. So why should we assume that Congress withdraw our jurisdiction to hear this case once the case was already lodged here?
I think the answer, Justice Ginsburg, is that you're right, this isn't like ex parte McCardle. What made ex parte McCardle so unique is Congress went after this court's appellate jurisdiction and that alone. What Congress has done here, which is not that unusual, and it certainly happened several times since McCardle, is that the court has modified the jurisdiction of all the courts, and that has had the effect of eliminating jurisdiction in this court over a pending case. That's happened any number of times. The Gallardo cases that we cite in our brief provide one example, and as Justice Holmes made the point there, it's not a situation where you go after this court's appellate jurisdiction as such. There it's a situation, as Justice Holmes put it, that when the root is cut, the branches fall. When the district court loses jurisdiction over these cases, then this court loses jurisdiction. But it's much less of an affront to this court than the kind of statute that Congress passed in the McCardle situation.
Mr. Clement, I for one, have lost track of your time. I'm interested in your arguments on the legitimacy and the regularity of these commissions.
And if I could talk to various aspects of that, I'm happy to do so.
Can I put that issue in? Don't ignore my question, which is the same as Justice Kennedy's, if it doesn't help. I'm trying to focus this. And in my mind, I take their argument as saying, look, you want to try a war crime. You want to say this is a war crimes tribunal. One, this is not a war, at least not an ordinary war. Two, it's not a war crime, because that doesn't fall under international law. And three, it's not a war crime tribunal or commission, because no emergency, not on the battlefield, civil courts are open, there is no military commander asking for it, it's not in any of those in other respects like past history, and if the president can do this, well then he can set up commissions to go to Toledo, and in Toledo pick up an alien and not have any trial at all except before that special commission. Now, I've tried to summarize a whole bunch of points for you to get at as you wish.
Well, let me try to hit a couple. Let me try to hit a couple of highlights.
I'll be interested in your answer if you can get it out.
Let me try to hit a couple of highlights. This is much more of a call for military commissions and a real war than certainly the use of military commissions against the Medoc Indians or any number of other instances in which the president has availed himself of this authority in the past. I think the events of 9/11 speak to the fact that this is a war where the laws of war are involved. As to whether or not the law of war encompasses the crime of conspiracy to violate the laws of war, we think that is clearly established. That is something that the United States treated as a valid war crime in the Civil War. That is something that the United States treated as a valid war crime in World War II. I would invite you, as to the former, to look at Winthrop's treatise, page 839, note 5. He makes it very clear that those conspiracies are not just conspiracies of municipal law, what he called of the first class, but they included the second class, which are classic war crimes. The most prominent examples are the Lincoln conspirators and a conspiracy at Andersonville Prison to deny POWs their lawful rights. Clearly, those are classic war crimes. In World War II, of course, conspiracy was also charged, and this court saw it in the Kearing case, although it didn't reach that element of the charge. Now, I think it's very important to understand that history because the most relevant text on this question is Article 21's reference to the law of war. And as this court was crystal clear in the Madsen case, what that reference is Congress's effort, when it extended the jurisdiction of the courts martials to include more and more crimes, that it didn't want to crowd out the military jurisdiction of the military commissions just because they had concurrent jurisdiction. And this court in Madsen said what Congress authorized was the jurisdiction of the military commissions as it existed in 1916. And then presumably again, when it passed Article 21 of the UCMJ, the jurisdiction that existed as of 1950. Well, in 1960, you could try conspiracy. In 1950, you could violate conspiracies to the law of war. So now let me try to get to the procedures that would be applicable. The argument that's made here is an extraordinary one, that Article 36, when it says that military commissions can deviate from the laws of evidence to the extent the President determines necessary, except that it must comply with the provisions of the UCMJ. Clearly what that provision means is the provisions of the UCMJ that specifically impose requirements on the military commissions. And there are 9 of them. And they impose some certain minimum rules. But to say that that provision incorporates all of the UCMJ provisions that put much higher requirements on courts-martials is to violate this Court's Madsen decision, which clearly recognized that there were differences between court-martials and military commissions. And although that was a case that addressed the Articles of War, Article 38 is identical to Article 36A of the UCMJ, so that's not a difference that matters. And if I could say the other thing is that just violates any normal principle of statutory construction, because then the 9 express references to the military commissions are rendered utterly superfluous. Clearly what Congress had in mind was that you must comply with those provisions of the UCMJ that apply specifically to the military commissions. If I could make this point clear, because I think it's helpful in reading the past cases, what made Yamashita and other of the World War II cases so difficult is that the President in that situation constituted commissions that violated even the procedural rules that the Articles of War made specifically applicable to the commissions. And so if you look, for example, at Justice Rutledge's dissent in the Yamashita case, he was at pains to emphasize that very few of the provisions of the Articles of War applied to military commissions, and the difficulty was that the military in that case was not complying with even those provisions that specifically applied to military commissions by terms. That's not an issue here. These military commissions comply with all of the provisions of the UCMJ that are specifically addressed to military commissions. So I just don't think there's a procedural problem here. The import of extending Article II jurisdiction to new individuals doesn't mean that anything in Yamashita as to this point is still relevant. What that does is it takes away the argument to the extent that these individuals are within Article II. It takes away the argument that the President doesn't have to even comply with those provisions of the UCMJ that are expressly directed to the military commissions. But that's not an argument we're making here. The argument on the other side of this is really that when Congress specifies that 9 rules apply to military commissions and everything else applies to courts-martials, that somehow all of them have to apply to the military commissions. And as Justice Scalia's question alluded to earlier, in order to accept that argument, you really have to believe that what Congress was doing when it was carefully preserving the jurisdiction of the military commissions was simply to preserve the option of calling something that had to comply with every single statutory requirement on the court-martials. They got to label it something else. They got to label it a military commission. Clearly, if you look at the legislative history of Article of War 15 and Article 21 as they were developed in the Madsen decision and discussed in the authoritative testimony of General Crowder, that's exactly what wasn't going on. They wanted to make sure that this argument that as we get more and more things that come within the military jurisdiction of the courts-martials, that somehow we're cutting back on the military commissions. That's not what they wanted. The next thing that may be lurking in the question is the question of what about the Geneva Conventions? And I think that very importantly, we have arguments that we have surfaced in our briefs that the Geneva Conventions do not provide relief in these circumstances, that they do not apply for various reasons. But the first question at the outset is whether this Court is going to overrule that portion of Eisentrager that basically said the Geneva Conventions are not judicially enforceable. Now, of course, this Court can say that was the 29 Convention and this is the 1949 Convention. But as the Court of Appeals correctly determined—
And there was a footnote dicta.
Well, I don't think it was dicta, Justice Stevens. If there's one thing I think the Eisentrager decision has, it's an awful lot of alternative holdings. And Justice Black was concerned about that and said, what are you doing reaching the merits when you have, said there's no jurisdiction? But the Court, as a holding, said that the Geneva Conventions of 1929 did not apply. There aren't any material differences about 1949 conventions. And I ask you to think about why that makes sense, because the 1949 Geneva Conventions were being negotiated contemporaneously with this Court's decision in Eisentrager. And even if you think the rule is different today, at that point, Justice Jackson was quite correct that the idea that an enemy combatant would get access to the domestic courts of a detaining power was absolutely absurd. And so what the framers of the Geneva Convention recognized that they were dealing with a group of people that were uniquely vulnerable, so they went to great pains to make sure there were mechanisms to enforce their rights. And so there are various provisions for party-to-party enforcement. There are various provisions for getting the protecting powers, which is now a role basically taken over by the ICRC, to get access to the detainees and to provide other mediating effects. So what you have is a treaty that's really written against the backdrop that, of course, these people aren't going to be able to get into the domestic courts of their the detaining power, if you look at the treaty and read it as a whole, I think it's almost impossible to read it as applying judicially enforceable rights in the domestic courts.